नमस्कार और गंगा एजुकेशन में आपका पुनः स्वागत है। इस प्लेटफॉर्म पर आपको विधिक क्षेत्र से संबंधित महत्वपूर्ण विषयों पर व्याख्यान, विधि से जुड़े हुए प्रतियोगी परीक्षाओं की तैयारी, महत्वपूर्ण कानूनी तथ्य तथा विधिक इतिहास से संबंधित सामग्री सरल और व्यवस्थित रूप में उपलब्ध होगी। आज के इस वीडियो में एक और इंटरेस्टिंग केस हम डिस्कस करेंगे, दैट इज पकाला नारायण स्वामी वर्सेस एम्परर।
Namaste dosto and welcome back to Ganga Education. I want you to imagine a steel trunk, just sitting there in a train compartment. But inside, there's no luggage. Instead, there's a human body, cut into 7 pieces. This horrifying discovery back in 1937 sparked one of India's most important legal battles. It's a case that hinged on 2 crucial statements. And in the process, it completely redefined the meaning of dying declaration and confession under the Indian Evidence Act. Today, we are dissecting the landmark case of Pakala Narayana Swami versus the King Emperor.
So here's our game plan for this explainer. First, we'll get into the facts of this chilling murder mystery. Then, we're going to dive deep into the 2 critical legal questions that the entire case was built on. We'll examine the evidence, break down the brilliant reasoning of the Privy Council, and finally, we'll zero in on the core principles and analysis that you absolutely need for your exams.
So, this case unfolds just like a classic murder mystery, built entirely on a chain of circumstantial evidence. But its real importance isn't just in the gruesome details, it's in the 2 powerful legal principles it established. Exam ke liye ye case bahut important hai, so let's pay close attention to the sequence of events.
The story kicks off with a loan. The accused wife had borrowed about 3,000 rupees from the deceased. On March 20th, 1937, the deceased gets a letter. He tells his wife he's off to Berhampur to collect that very debt from the accused wife. The next day, he leaves. On March 22nd, a steel trunk is bought, apparently on the instructions of the accused. And then, on March 23rd, the deceased's body, cut into pieces, is found inside that same trunk on a train at Puri station. During the investigation, the accused gives a statement to the police.
Now, to understand the legal fight here, you need to know about 3 crucial sections. First up, we have Section 32, Subsection 1 of the Indian Evidence Act. This deals with the statement the deceased made to his wife. On the other side, we have Section 162 of the Criminal Procedure Code and Section 25 of the Evidence Act. These govern the statement the accused made to the police. Yes sections exam mein frequently puche jate hain, so let's see how the court interpreted them in this specific case.
So really, the whole case boiled down to the admissibility of these 2 statements. These were the 2 critical questions that the Privy Council had to resolve.
Issue number 1. Could the deceased's statement to his wife, the one about going to Berhampur, be considered a dying declaration under Section 32(1)? And issue number 2. What about the accused's statement to the police, where he admitted the deceased came to his house, but also added things to clear his own name? Was that a legally valid confession?
The prosecution argued that the deceased's statement was part of the circumstances of the transaction that ultimately led to his death, so it should be admissible under Section 32(1). The defense countered this, saying the deceased wasn't under any fear of death, so it couldn't possibly be a dying declaration. Regarding the accused's statement, the prosecution said it led to the discovery of facts, while the defense argued it was totally barred by Section 162 of the CRPC and Section 25 of the IEA, and, well, it wasn't even a real confession to begin with.
Now, it is absolutely crucial to understand this. There were no eyewitnesses in this case, no direct evidence. The entire prosecution was built on a chain of circumstantial evidence.
So let's quickly understand the difference. Direct evidence, like an eyewitness testimony, proves a fact directly, no guesswork needed. Circumstantial evidence, on the other hand, is like a chain of different facts. When you link them all together, they lead you to a logical conclusion. And remember, a strong, unbroken chain of circumstantial evidence is often more than enough for a conviction.
Okay, now we come to the most important part of this case, the reasoning of the Privy Council. This is where the court gave an interpretation of 2 major provisions that is still taught in law schools all over the country.
So, the first big question the court had to answer, was the statement that the deceased made to his wife admissible as evidence?
And the court's answer was a resounding yes. That statement is admissible. Court ने यहाँ एक important principle दिया. They gave a very, very wide meaning to the phrase circumstances of the transaction. The court clarified that a statement doesn't have to be made right before death or under the expectation of death. If a statement is about the reason or destination of a journey that results in death, it will be considered part of the circumstances. This was a really significant and forward-thinking interpretation of the law.
All right, now let's move on to the second, and arguably more complex, question. Was the statement the accused gave to the police actually a confession?
And right here, the Privy Council gave us a definitive test for defining a confession. They said a statement is a confession only if it's a direct admission of guilt. Or, at the very least, it has to admit to all the facts that together make up the offense. And, most importantly, if a statement contains anything that tries to save the person making it, what we call self-exculpatory matter, then it cannot be considered a confession. Ye concept yaad rakhna. It's absolutely crucial.
So, based on that very definition, the court ruled that the accused's statement was inadmissible. Why? Well, first, it was barred by Section 162 of the Croc PC, because it was made to the police during an investigation. Second, it just wasn't a confession. Why not? Because it had self-exculpatory stuff, like the claim that the deceased left my house alive and well. You see, just admitting one incriminating fact, like, yes, he visited my house, is not the same as confessing to the entire crime.
So now we get to the big question. You might be wondering, if the accused's statement was ruled inadmissible, then why was his conviction upheld? This is a common point of confusion, and we're about to clear it up. And by the way, if you want more simplified case laws just like this one, make sure you hit that subscribe button.
Okay, let's move on to the final verdicts in this case and the groundbreaking principles that came out of it.
The Privy Council dismissed the appeal and upheld the conviction. Their reasoning was this. Even though the accused's statement was wrongly admitted, if you take it out of the equation completely, the rest of the circumstantial evidence, like the purchase of the trunk, taking it to the station, and the victim's stated purpose for his journey, was so strong and so overwhelming that it formed an unbreakable chain pointing directly to the accused's guilt. Therefore, there was no failure of justice.
So, from this case, we get two golden principles that you have to remember. First, the scope of a dying declaration is very wide. It includes all statements that describe the circumstances of the transaction which led to the death. Second, the test for a confession is very strict. Any statement that includes self-exculpatory matter cannot be a confession. ये case हमें ये powerful principles देता है.
All right, now let's analyze this case specifically from an exam perspective. Why is this case still so essential for every law student?
The legal impact of this case is huge. It provided so much clarity on Section 32(1) and the definition of confession that it's been cited in countless cases since then. Its strength lies in its logical clarity. One criticism is that the definition of circumstances could be a bit vague, but the court did try to limit it to events that have a proximate relation to the death. So here's your exam tip. You must always clearly distinguish between an admission and a confession, and understand the wide scope of circumstances for dying declarations.
All right, let's test your understanding. Answer this MCQ according to the Pakala Narayana Swami test. Which of these statements is not a confession? Post your answer in the comments below. And remember, like, share and subscribe to Ganga Education. यहाँ law समझाया जाता है.
And here's the second question. The principle that a statement about the purpose of a journey can be a dying declaration was established in which landmark case? This one should be easy.
And finally, for your mains exam practice, here's a question. Critically analyze this statement and explain the difference between an admission and a confession. This question will really take you into the depths of this case. Definitely try to write an answer for it. We'll see you in the next case analysis.
इस सत्र को देखने के लिए धन्यवाद। यदि यह व्याख्यान आपको उपयोगी लगा है तो कृपया लाइक, शेयर और गंगा एजुकेशन को सब्सक्राइब करें और आगे भी ऐसे महत्वपूर्ण विधि व्याख्यानों के लिए जुड़े रहें।